through with the witness? Are you through?
Yes, Your Honor.
All right. The witness is discharged.
Mr. President,
Oh,
Senator Miriam Santiago wishes to ask questions.
wait.
to
Let's
the,
discharge first the witness.
yes, to the witness, Mr. President.
Toby, you can now go. You can now go.
Yes, we cannot discharge the witness, Mr. President, because Senator Santiago wishes to ask questions to the witness.
So the lady member of the court from Iloilo is now will now have the floor to ask with questions.
Unfortunately, Mr. President, Senator Santiago wants to ask the questions tomorrow.
Well, anyway, we will discharge Toby now.
For today.
For today.
But
Toby,
ask him to return tomorrow, Mr. President.
please bear with us. You come back tomorrow.
Tomorrow at 2 o'clock.
All right?
I have no choice, Your Honor.
Pasensya ka na. So, are you presenting another witness, Mr. Counsel?
Your Honor, please, we have requested subpoena for the appearance of these witnesses, Your Honor. And luckily enough, we filed it last week up to now.
Who are these witnesses?
We have... Ano ba yung huli? Ano ba yung huli? Ano ba yung huli? Hindi, ano ba yung huli? Uy, ikaw.
So, permission to leave for today?
Yes, you're discharged.
Toby, you can now go home. Just come back tomorrow. Huh?
Sorry.
Did you deny this? I understand that this request for subpoena duces tecum could not be granted because their testimony, according to the request for subpoena, is related to the issue of verification. So we have not. Have we released the it was already decided in open court a while ago.
In view of that development, Your Honor, we will not touch on the question verification, Your Honor. We will present them on other aspects of the case, Your Honor. Your Honor, please, we are referring to Congressman Mandanas and Congressman Remulla, Your Honor, together with Congressman Rufus Rodriguez, Your Honor. Now, this afternoon,
so you are going to use them as witnesses for other matters.
Correct, Your Honor.
All
Very
right.
correct.
Yes, we will grant the subpoena.
No, we have an opposition to that. We filed an opposition, Mr. President, today.
Just a minute. Just
point of
one by one.
clarification.
That's the pleasure, gentlemen.
Point of clarification, Mr. President. I thought we had a ruling before that members of a co-equal branch of government or for members of a co-equal branch of government will not issue subpoena. The same manner that we ruled that we will not issue a subpoena against members of the Supreme Court.
Now we have...
Please correct me if I'm wrong, Mr. President.
Mr. President.
Your Honor, we have talked with this congressman, Your Honor, and they are very much willing to testify, but they wanted at least that they should be subpoenaed, Your Honor. That is the,
Mr. President, may
that
I...
is the request, Your Honor.
Mr. President.
Just one by one, please.
Mr. President.
Let me hear the gentleman first. Proceed.
We are through, Your Honor. We stated.
What's the pressure of the majority for
I would like to concur with Senator Lacson, Mr. President, just to remind the court that we did have an agreement to that effect. Now, if the defense would like to present them as witnesses, they can present themselves
Can you present them?
voluntarily, and we will have no problem with it. But for us to issue a subpoena, we will be violating our own rule.
How about an invitation, Your Honor?
Even an invitation, Mr. President, we did not issue that to a Supreme Court justice and to a congressman that the prosecution was asking for. The sauce for the goose will be the sauce for the gander, Mr. President.
The problem with the alleged prohibition is when there is an objection on the part of the person or party subpoenaed, Your Honor. In this case, we were assured when we talked to them that they have no objection to being subpoenaed. Only they wanted to make it clear that they are coming over pursuant to the subpoena.
May we be heard, Mr. President? May we be heard, Mr. President?
Yes.
We respectfully oppose that, Mr. President, because in the case of Justice Sereno, this honorable court also told us that we should, on our own, invite her if we wish, and this honorable Senate never extended the invitation, much more a subpoena. And may we inform the honorable Senate that the rules of the House under Rule 23 governs response to subpoenas, Your Honor, and there are procedures that we will have to follow, and we invoke inter-chamber courtesy, Mr.
May I suggest, Mr. Counsel, that you talk to these members of the House, if indeed they want to testify in the interest of justice, to appear here voluntarily, because we do really have this problem about subpoenaing our counterparts in the House of Representatives.
Will this position of the Honorable Impeachment Court, Your Honor, be equally applicable to adverse parties, Your Honor?
No, if they're adverse parties, I think
Then
they are here, so I'm sure that they can testify and they can take care of themselves.
okay, then, Your Honor, we will just continue with our reiteration of a subpoena to these adverse parties, Your Honor.
No, well,
Namely,
you can ask them to testify if they're here. We do not have to subpoena them.
Mr. President,
The adverse parties are complainants in this case.
but Mr. President, may we be heard, Mr. President? The adverse party here now is the House of Representatives, Mr. President, not the individual members, because this was filed already by the House of Representatives. Sir, there are no private
But
complainants. sir.
actually, the representation of the House of Representatives are the named complainants here. And I think in the interest of justice, why can you not take the witnesses stand? They will ask you, did you prepare this complaint?
In the same manner, Mr. President, because what if they will call all 188
we will not,
parties,
Your Honor. That's far-fetched.
and
They're not adverse parties, they're just filers.
so who are the adverse parties here, Mr. President? Just the ones named?
The identified members of, I cannot subpoena et al, you know. I can subpoena only the named complainants here. In the matter of the impeachment of Renato C. Corona as Chief Justice of the Supreme Court, Representative Neil Topas, Emilio Abaya, Lorenzo Artañada III, Reynaldo V. Umali, Arlene J. Bagao, complainants.
Mr. President,
Mr. President,
it says here, Mr. President, other complainants comprising at least 1/3 of the total members.
They already made a statement in the record that they will not call the et al. Am I correct in this?
Yes, Your Honor. We have
Alright.
definitely named them and positively identified them.
Mr. President,
Yes.
considering the nature of the issue, may we request that this matter be discussed in caucus?
All right.
Yeah.
All right.
Okay, then
We will discuss it.
we
in
submit, Your Honor.
May you recognize Senator Estrada, Mr. President.
The gentleman from San Juan.
Maraming salamat, Ginoong Pangulo. Habang ako po'y nakikinig sa mga debate ng ating mga magaling na abogado dito, miyembro ng hukom na ito at ang Defense Council at ang testimonya ni Congressman Chanco. Hindi ko po alam kung saan ko i-connecta yung testimonya ni Congressman Chanco sa aking pagdedesisyon pagdating ng araw. Alam niyo po ang ating Defense Council, kung ang inaalala niyo yung verification ng complaint, palagay ko na nakapag-rule na po yung Senado dyan. Assuming na yung 188 congressmen na yan, assuming lang ay hindi binasa, basta lang pumirma, nasa jurisdiction na po ng Senado yan. Yan, tulad ko lang po yung impeachment case ni dating Pangulong Joseph Estrada, with all due respect to then Speaker Manny Villar, kahit minadali ng House of Representatives, napunta na po sa Senado yan, under jurisdiction na ng Senado yan. Kahit umayak kami, maglupasay kami sa Malacanang, wala rin kami magagawa dahil nasa jurisdiction na po ng impeachment court yan. So, ang hinihintay po ng tao, Ginoong Lead Counsel on Defense, kung magrepresenta po tayo ng mga witnesses, katulad ni Congressman Chanco, magsasalita tungkol dyan sa mga verification ng complaint niya, nakakantok na ho eh. Ang kailangan ho namin malaman, kung meron kayo mga testigo, magpapatunay dun sa salin ni Chief Justice Corona. Yun lang po ang hinihintay ko at yun lang po ang hinihintay siguro ng impeachment court at yun lang siguro ang hinihintay ng taong bayan para kung sa gayon ay makapag-desisyon na kami kung ano ba talaga ang magiging desisyon namin, whether to convict or to acquit the Chief Justice. Yun lang po, maraming salamat po.
Thank you, Mr. Senator.
We thank the gentleman from San Juan for the manifestation.
From Las Piñas, the Senator.
Mr. President, just to set the record straight, the impeachment of the then President Estrada was about 1 month, not 2 days. Isang buwan po yun halos. Nagkaroon po ng hearing sa Senado, 4 na hearings. Sa Senado muna, si Senator Gingona. And then after that, yung I accused ni Senator Gingona. And then, ipinail po yan sa House. Mga 1 buwan po at nagkaroon ng 2 hearing sa committee. Just to set the record straight, 2 hearing po yan sa Committee on Justice. Bago po yan, napakakuha ng pirma ng 1/3. At iba po ang impeachment against a president, a sitting president. Because then, ang pipirma po ay mawawala ng anumang benepisyo sa Kongreso. Iba po naman, ang pipirma kayo nang naaayon sa gusto ng Pangulo. There is a big difference, Mr. President. It is 100 times different. I've been hearing about this, hindi po ako kumikibo. Now my name was mentioned, I think it's about time I say this. Iba. Hindi po binadali yun. And when you sign an impeachment against a sitting president, you are prepared to lose everything. We heard earlier how Congressman Toby was telling us about he was afraid to lose benefits if he did not sign. But here is the reverse. So, nakaraan na po yan. Ayoko naman pong i-bring up pa yan. Pero nabanggit po, mabuti na rin, gusto ko na rin pong i-bring up yan in this impeachment trial, that there is a big difference There's a big difference between that impeachment and this impeachment. We were then impeaching a sitting president. When you sign an impeachment against a president, napakalaki pong bagay niyan. When you sign with the president, wala pong problema yan. I do not want to show how I will vote because I do not know yet. Pero kanina po, wala naman masama mapakinggan siguro yung mga sasabihin ng mga congressman kung gusto nila magsalita. Lahat naman po ng nagsalita sa prosecution, pinakinggan natin, including nasabi yung testimony ni Secretary de Lima na hearsay pero pwedeng ilagay sa record. Sa tingin ko naman, wala naman pong masama yan. Napakahirap po na kung tayo ay mag-a-acquit, ang masabi na nag-acquit tayo maski na walang ebidensya at napakasakit naman po kung tayo magko-convict na hindi nagkaroon ng justisya ang accused. Kaya po ako hindi kumikibo, subalit bakit di po natin pagbigyan ng parehong kapanig? May oras po naman tayo. Sana lahat ng maging desisyon natin ay mag-igagalang ng ating mga kababayan na kung mag-acquit dahil walang ebidensya, hindi convincing, at kung mag-convict naman, ay masasabing binigyan natin ng hustisya at pinakinggan natin ang accused. Yun lang po, Mr. President.
Salamat.
Senator Estrada, Mr. President.
The gentleman from San Juan.
Well, although I respect the opinion of my colleague here, Senator Villar, I do not want to belabor the point anymore because it's already useless because this is already history. But what I was not actually complaining is the manner of how fast the transmittal was when it was transmitted here in the Senate. Well, although there was a lot of maybe the hearings that Senator Villar pointed out, yung hindi ko masabi kung railroaded or baka naman magalit na naman sa akin magalit si Senator Villar. I think on my part, I hope he respects our opinion or my opinion that the impeachment case against President Estrada was really railroaded during that day when it was transmitted here in the Senate. And again, Mr. President, I do not want to belabor the point because it is already history. And what I want to hear from the defense is the witnesses who can testify with regard to the sal-en of the Chief Justice. Thank you very much, Mr. President.
All right. The gentleman from
Mr. President,
Las Piñas.
I just stood up just to say that I respect the opinion of my colleague. And I will no longer say anything on this case.
Thank you. Mr. Counsel for the defense, and are you ready to present other witnesses?
Your Honor, please, we are sorry to state for the record that we are not ready because these witnesses are not available yet.
All right.
So
Then,
we will ask.
There is a request by a member of the court to discuss the matter regarding adverse parties testifying here in the caucus, and we will take that up in the caucus.
Thank you, Mr. President.
Can you present other witnesses before
Tomorrow.
we settle the issue regarding the testimony of the adverse parties?
We thought, Your Honor, that the two congressmen we have mentioned will be coming over, notwithstanding the fact that the subpoena had not yet been issued. But to our disappointment, Your Honor, they could nowhere be found. So we will ask for another day for them, Your Honor. If we may be able to convince them to come over, even without a subpoena, we will do so, Your Honor, in compliance with the suggestion of the Honorable Impeachment Court.
The Congressman Toby Tiangco came here voluntarily to speak out. I hope the others will do so also, so that we can hear their side.
We are hoping against hope that we will arrive at that point, Your Honor.
Okay.
Thank you.
Mr. President,
Mr. President, may we know the order of presentation of their articles for the defense, Mr. President, so as for us to be able to prepare also for our cross-examination?
Well, the defense may do so if they wish, but my statement, counsel, for the prosecution is that before you started coming here for trial, you should have already some notion of how to cross-examine the possible witnesses of the defense. That's a rule of trial.
But we're just asking, Mr. President,
That means you have a trial brief, how to present your direct examination, your evidence in chief, and how you handle your cross-examination. Point by point, article by article. Because I'm sure you should have anticipated the witnesses that will defend the respondent per article.
we are aware of that, Mr. President, but in the same manner that the prosecution was directed to also present its order of presentation of articles, we're also asking them.
Anyway,
we already did it earlier, Mr. President.
they may, if they want.
We gave them a directive earlier, Mr.
There's
President.
already a
to present.
ruling.
Yeah.
We would like to, we already gave a directive earlier. The court already gave them a directive earlier to submit.
But I mean, the chair was just reacting to the statement of the distinguished counsel, so that they will know how to prepare for their cross-examination.
Yes,
I'm sure that if I were in your place, by this time, any witness that will come to be presented against my case, I'm ready to cross-examine.
Thank you. Mr. President, may we recognize Senator Recto?
Senator Recto is recognized.
Thank you, Mr. President. Thank you, Majority Leader. Mr. President, I do have a copy of the compliance submitted by the defense with regard to the witnesses and documents that they intend to present during the time, and the time has come, to defend the respondent in this case, which is the Chief Justice. And as far as the affirmative defense is concerned, it lists down more or less 5 witnesses. I think we're done with the first. No? Now, for Article 2 here, assuming we go by the particular order, that was my other question earlier that I wanted to ask the defense. No? That on Article 2, there are roughly 9 witnesses in the compliance document submitted to the court. So my question now is the intention for orderly proceeding and for us to be able to prepare as well in this chamber, is it my understanding from the defense counsel that you will continue with 4 other witnesses for your affirmative defense?
No, when we made that announcement, Your Honor, or arrangement, we were not clear about the impact nor the coverage of the order of denial or resolution of denial, Your Honor. With this order of denial barring us from presenting evidence on the affirmative defenses, Your Honor, then we will have to change our course of action, Your Honor.
Yes, I understand that, and that's fine with me. With regard to Article 2, there are 9 witnesses listed down here. Do we expect any changes as far as the 9 witnesses?
As of today, Your Honor, we do not intend to make any changes, Your Honor.
So more or less, we will be following the compliance document as far as Article 2.
Correct, that's correct, Your Honor. Thank you,
And
Mr.
for
Senator.
Article 3, there are only 2 witnesses listed in the compliance.
That's correct also.
And for Article 7, there are only 4 witnesses.
That's correct, Your Honor.
And I take it that at this point in time, no amendments or there are no changes.
No, we have not heard yet the testimony of these people whom we intend to present.
Yes.
So that will highly be dependent on us, Your Honor. If in our appraisal there is no necessity or further imperative necessity to call other witnesses, then we will not do so.
In total, Mr. President, just for the food for thought for the impeachment court, there are 15 witnesses listed. Thank you, Mr. President.
Thank you also, Mr. Senator.
So, what is the pleasure now of the House?
Mr. President,
The floor leader.
may we go now to other matters?
Yes.
Yes, Mr. President, Attorney Vitaliano Aguirre, a private prosecutor, was cited for contempt during our last hearing. The penalty to impose upon Attorney Aguirre was agreed to be discussed in caucus. Related thereto, Attorney Aguirre has filed a withdrawal of his appearance as a private prosecutor. Also, there is a pending motion of Senator Trillanes to rule on the participation of the lawyers in a press conference regarding allegations of offer of 100 million pesos to each senator judge. The issues have been fully discussed, so the impeachment court is ready to rule, Mr. President. We would like to ask for your ruling.
Well, as I said previously, the court finds it prudent, because of the attendant circumstances, to impose a penalty of admonition upon Attorney Vitaliano N. Aguirre II, in view of the fact that he already filed a withdrawal of his appearance as a private prosecutor in this impeachment case. And in addition, I think he made an apology. However, the explanation and apology from on the other hand, there was also this motion of Senator Trillanes on the participation of certain members of the certain lawyers in a press conference regarding allegation of offer of 100 million to its senator judge. And I think the court feels that in effect there is an implied suggestion that there is a quid pro quo in the votes to be obtained from the members of this court, which this court considers an indirect contempt of the court. And so therefore this court is constrained to cite the one of the lawyers of the defense, Attorney Roy, for contempt. The penalty to be imposed will be subject of a determination in a caucus of this court. So ordered.
I thought it's either life or life imprisonment or death penalty.
That will, no, we do not. We do not go that far. We will.
I just said it in jest, Your Honor. I apologize.
I understand, but that could be misunderstood by the public, and I hope that, with due respect to the defense, this court must assert its dignity and honor in this proceeding, and we are going to think about the penalty to be imposed upon him commensurate to the degree of the what we consider to be an accusation to the members of this court. The implication of the statement of one of your members is rather serious. Because it in effect suggests that this court would be paid in making a decision. And I don't think that is a proper thing to even think about this impeachment court. We may be politicians, but we have our own integrity and honor that we have earned over time. So we will take up the commensurate penalty that we will impose against the erring member of the defense panel. So ordered.
Thank you. Thank you, Mr. President. We assure the Counsel of the Defense that it is not like what he said, but Senator Honasan says something to that effect.
Grabe pala. I said I was just...
Mr. President, in compliance with the request of a member of the impeachment court, the prosecution submitted the transcripts of all videos presented to the court on February 27 and 28, just for the information of the court.
Noted.
May we ask Sergeant Adarns to make an announcement, Mr. President?
Please all rise. All persons are commanded to remain in their places until the Senate President and the Senators have left the session hall.
Move to adjourn until 2 o'clock in the afternoon of Tuesday, March 13, 2012.
Is there any objection? There being none, the trial is hereby adjourned until 2 o'clock of Tuesday, March the 13th, 2012. So ordered.
Good afternoon. Day 27 of the impeachment trial of Chief Justice Renato Corona has just ended. So today, actually, certain interesting issues have been raised. First, the defense presented their first witness, Representative Toby Tiangco of Navotas. Tiangco said that he talked about the impeachment of the Chief Justice in the House and what events transpired on December 12, 2011, when the impeachment complaint was filed. He said that lawmakers were not allowed to ask questions on the complaints, and when he had entered the meeting that day, that the House Speaker, Sonny Belmonte, said, "Today, we will impeach the Chief Justice." Now, he said they were pressured by the palace to impeach Corona. According to the defense, the testimony of Tiangco is important as it raises questions on the integrity of the complainants and on whether or not these grounds are impeachable. Tiangco will return tomorrow to answer questions from senator judges. Now, as expected, the defense counsel also addressed what they consider the crux of the problem. They argued that the complaint is null and void, especially after Tiangco's testimony, saying that it proved that the complaint was railroaded since the congressmen were not given enough time to read it before signing. Now, the Senate Impeachment Court denied the defense's request for verification of the impeachment complaint, saying it has sole jurisdiction to try the case. Senator judges also reiterated that it is too late to bring up this concern since the prosecution has already rested its case. Now, if you remember, the defense has already submitted a petition raising the exact same issues regarding the complaint with the Supreme Court, wherein they asked the High Tribunal to stop the proceedings against Corona. That complaint or that petition is still pending in the Supreme Court. Now, certain decisions were also made by the senator judges in the caucus this morning. Senator judges, first of all, decided to admit most of the evidence the prosecution presented, including both the peso and the foreign accounts of the Chief Justice, the bank accounts, rather, of the Chief Justice. The one evidence that they did not admit related to the accusations of bribery, because they said that this was not included in the verified complaint. The documents that were not admitted related to the Philippine Airlines records that showed Corona traveling multiple times using his PAL Platinum card. Now, the Senate also denied the defense's request for subpoenas of other congressmen and instead said that if they want the congressmen to testify, then they should invite them themselves. They will not issue any subpoenas. Also, they decided not to act on the defense's motion to dismiss the 5 articles dropped by the prosecution. But perhaps the most interesting decision that the senator judges made today was to cite attorney Judd Roy in contempt. Now, this is interesting because it has been an issue that has been a long time waiting. And if you recall, he is being cited in contempt for a press conference the defense held on February 12, alleging that senator judges had been offered 100 million pesos to vote for a temporary restraining order that was issued by the Supreme Court and to follow this temporary restraining order. There is currently now a press conference being held by the prosecution. Let's hear what they have to say.
In the interest of justice, while they cannot subpoena you and the others who signed as the chief complainants, baka raw you can voluntarily appear na lang before the court. Have you thought about this po? Handa po ba kayong tumestigo?
We will talk to our colleagues first with regard to this, no? Dahil there are certain implications that we want to avoid with regard to this issue. So, kailangan pagkausapin muna namin yung mga colleagues po namin.
Malinaw naman no, na sinabi na namin dati pa, bago pa nga magsimula ito, In fact, last week pa lang, nung nagsisimula pa lang tayo, nung tinitingnan natin yung kanilang compliance ng list of witnesses, it was clear to us that they were going to create a sideshow. And the sideshow is to put Congress on trial. It is to put the members of Congress as witnesses so that these very same individuals, siya rin huhubaran dyan, at ipakikita yung weaknesses nung complaint at as well as yung issue ng validity, which are all matters na settled na. Pinag-usapan na po yan, and in fact, yung bagay na yan ay nasa Supreme Court, dinala pa mismo ng defense doon. So, as far as we're concerned, it is a diversionary tactic on the part of the defense. Wala pong iba. Napakarami nilang ibang testigo na pwede nilang ipatawag, which will go into the meat of the defense. Kung matandaan po ninyo, kanina, sinabi ni Justice Cuevas, in fact, we did not oppose anymore, but had we actually, only because we had decided na wag na nating tutulan yung pagpresenta kay Congressman Toby, kanina, dahil sa tingin namin ayaw pagbintangan na binubusalan natin ang katotohanan. Pero after the Senate Impeachment Court made a decision that they will not accept any evidence pertaining to validity, we could have actually objected to Congressman Toby's presentation, but we did not. But all of the statements of Congressman Toby pertains to the validity of the complaint, nothing else. He talks about issues and questions even on motives, which the Senate surprisingly allowed. We were surprised because when we were trying to prove the motive on the part of the Chief Justice, and it was very clear with the Palfasab case that the motive was, we wanted to present that he was accepting free business and first-class tickets from Philippine Airlines, we were not allowed to make that presentation. But we were surprised that today, motive was essentially the reason for which he was presented. But be that as it may, Congressman Toby did not bring anything new to the table. Like as we said, these are all old issues that had been brought about already by the Chief Justice as well as by his main counsel, the Integrated Bar of the Philippines. Nilabas na nila lahat yan nung December pa. Lahat ng usapin na pinag-uusapan. So there's really nothing new. That matter had been discussed and resolved by the Senate Impeachment Court on January 18. We see no reason why the substantial witnesses cannot be presented unless the defense actually has no available witnesses. We are almost tempted to think that, because they've had more than almost 2 weeks to prepare for today. They should have at least had witnesses. They filed the request for subpoena. They said we had presented it a long time ago. They presented it Friday. They filed the request for the issuance of a subpoena around lunchtime Friday for witnesses that are supposed to be compelled to be present today. So obviously, they've had 2 weeks to prepare, but they have not been able to fully utilize that. We're not condemning the defense, but now we also see how it feels to be on the other side, no? But like I said, I think what is important is that there are other available witnesses. I hope that the Senate can take cognizance of the fact that the defense wants to create a sideshow to divert the attention of the public, as well as the senators, when it comes to the merits of the case, which is the SALN, the real properties that he did not declare, the Palfasab case, and the TRO issuance. Sana doon na po tayo.
Sir, your reaction po to the impeachment court citing Attorney Roy for contempt?
Well, it's to be expected. To impute and attack the integrity of the court, no, is a serious charge. So we await what penalty would be imposed on Attorney Roy.
Sir, si Raymond ulit sa DZRH. Yung kay Congressman Toby Chanco, kasi lahat ng inilahad niya roon sa impeachment court, resulta po ng caucus. May maraming mga nagtatanong kung dapat na talagang i-pursue yung disciplinary action kay Congressman Chanco. Matutuloy yung expulsion.
That's a matter that is left to the discretion of the individual members of Congress or to the Committee on Ethics on what they want to decide. But we, as far as the prosecutors are concerned, or the panel of prosecutors who are here today at the Senate, our concentration is really just the prosecution of the Chief Justice and nothing else.
You guys na nasa prosecution team, you're not interested na reklamo siya sa Ethics Committee or i-push yung pagpaparusa sa kanya ng House of Representatives?
He stated an opinion, which unfortunately, well, si Congressman Sani has a statement on that. Yeah, I think what is clear is everything that we heard about from Congressman Toby is an opinion based on his own reading, based on his own statements, coming from a member of Congress who did not agree with the impeachment complaint, who did not sign the impeachment complaint. So, we respect his opinion, but the three of us, as well as the 188 others who signed the complaint, absolutely disagree with what he is saying. That is his conclusion. Unfortunately, the vast majority of Congress does not agree with him on this matter. The three of us, in fact, even before this, Sonny and myself, I'm pretty certain of that. I was in possession of the impeachment complaint even before the meeting started. So I had read it already. The very same copy I gave to Congressman Sonny. Sila Erin had their own respective copies. So as far as we were concerned, we read it. So if Toby did not read it, that is his experience. Maybe because we were there earlier than the rest, but certainly we made a judgment on the basis of what we were able to read nung hawak na naming complaint.
Can the Ethics Committee motu proprio investigate or do a process against Congressman Tiangco?
The rules allow it. The rules of the House of Representatives allow the committee to motu proprio undertake. But like I said, in my mind, honestly, today, while we don't want to impose on the Ethics Committee or on the members of the House, I think it's just going to be a distraction if we actually do anything like that. And that is something that we do not need right now. We want to focus our attention principally on the Senate impeachment court. And secondly, we honestly did not see anything hurtful or damaging on the part of his testimony. So there's nothing new. Those things have all been dispelled for quite a long time. What is more important is none of the 188 members have actually withdrawn. I think that's the most significant fact. In fact, more than 200 already have, since there were like 16 others who signified that they wanted to belatedly support. Yun ang importante. Yung 188 hanggang ngayon, walang bumabawi doon sa kanilang statement that they verified that impeachment complaint.
Tsaka matalino naman ang mga senador, palagay ko makikita nila yung opinion po ng isang miyembro ng House of Representatives ay hindi representative nung 200 na pumirma po. I think magiging klaro yan sa ating paglilitis na yung isang testigo na hindi naman pumirma ay may kaibahan siguro yon dun sa 200 na pumirma po.
Will that be damaging?
No, it won't be damaging, Weng. It's still, well, if they will talk again about the same things that Toby Tiangco mentioned, then it would not be damaging. If that will just add to what? Toby, Rufus, Mandanas, Boying, 4 out of the 200. It will not make an effect because again the Constitution is very clear. You need 1/3, no, to file an impeachment complaint directly to the Senate, and we got more than 1/3.
So wala yung benefit of the doubt na ginugusto for 8 ng defense sa mind ng Senator Chavez?
I think yung defense is trying to go around the back door eh. Hindi nila nakuha dun sa front door kasi nag-rule ang Senado na yung verification issue, sarado na yan, napag-usapan na yan, ha? Tapos na yan. So naghahanap sila ng paraan, sinabi nila ang purpose, isasabihin na hindi substantial yung grounds, at pangalawa, walang integridad yung mga complainants. Pero pag titingnan mo yung testimonya ni Rep. Toby, wala naman hong connection dun sa purpose eh, yung sa integridad. wala naman ho siyang sinabi na walang integridad yung mga kasama namin. Dun sa grounds of impeachment, wala ho siyang sinabi regarding Articles 2, 3, and 7. Everything yung sinabi nila pertains to the verification. Halos lahat pertains to the verification, the process, at yung personal opinion niya as to why he did not sign the impeachment complaint. Sa amin, okay lang yun. Wala kaming duda na nagsasabi ng totoo si Congressman Toby sa kanyang ng kanyang saloobin, ng kanyang opinion, pero walang connection po dun sa purpose na ino-offer para sa kanya at walang connection po dun sa charges against CJ Corona. Yun ang bottom line po.
Tsaka you cannot establish, the defense said that he was being presented to establish a pattern. What is that pattern? Nag-iisa lamang siya. And in fact, yung pattern na tinutukoy niya, base sa, like I said, hindi namin pinabubulaanan yung sinasabi ni Congressman Toby. Karanasan niya yan, sabi niya, naipit ang kanyang PDAF. Pero marami pang iba na congressmen na bumoto para doon sa impeachment na hanggang ngayon hindi pa nagkakaroon ng full release din ng kanilang PDAF. Sinabi niya, na-release yung kanya. Na-release din yung 2011 pero na-delay din. So, maraming iba, both those who actually did not sign have had their PDAF released, while those who have actually signed it, marami pa dyan na hindi pa nare-release ang kabuuan. So, if you're looking at the pattern today, I don't think you've been able to establish that pattern simply by presenting one witness, not even with two. And the rules of court are very clear on that, particularly in the rules of evidence. So, it has to be more substantial.
Sir, papayag ba kayong isabpina ng Senate, yung House members, considering that they rejected your request to subpoena the Supreme Court justices?
I think klaro dun sa discussion nila Senator Soto at Senator Enrile that they will not be subpoenaing members of the House, pati na rin yung pag-i-issue ng invitation. Pero kaparehas nung ruling nila in the case of the Supreme Court Justices, kung kusang loob pupunta dito sa korte, papayagan po nila tulad ni Rep. Toby Tiangco po.
Dagdagan ko lang, no? Tatlong bagay.
Tatakal pa daw sa caucus, sir.
Oo nga, hindi kasi
parang walang final.
Hindi, minsan yung decision ng Senate, mapansin nyo, firm na firm sa simula, pero parang minsan well, something happens. But anyway, they're deciding on that in caucus. Pero tatlong bagay lang. First is that that's already been decided upon. Meaning, sabi nga ni Senator Soto, the majority leader, sauce for the goose is sauce for the gander. Kung ano ang sarsa sa manok, hindi na sarsa sa itik. Pwede ba yun? No? So, ibig sabihin, hindi naman po pwede nag-decide tayo, RG mali ba? Di ba parang parehong sarsa? Pero ang punto namin is, there was a clear decision. We kept asking for the issuance of a subpoena on court employees as well as on members of the Supreme Court. Dininay yun because hindi yan po pwede. You cannot use the Senate Impeachment Court and its compulsion power to gather evidence. Kayo dapat na naghahanap niyan. Hindi nyo pwedeng gamitin ang Senate Impeachment Court to gather evidence. That's the very first argument. Second argument is, sabi ng Senate Impeachment Court, we cannot do that against a co-equal. But if they voluntarily want to do it, let them do it if they want to. But we cannot compel a co-equal. Otherwise, wala nang katapusan ito. In terms of, pwede ipatawag ang mga senador sa House of Rep, pwede ipatawag ang mga justices sa House of Representatives. So, hindi na magiging healthy yan. Pero kung voluntary, why not? Pero pangatlo, there is a pending case before the Supreme Court on certiorari and people keep forgetting about that case filed by the Chief Justice himself in his own hometown. Nag-file siya doon at meron siya doon sinasabi niya na invalid yung complaint. Meron na siyang kaso doon. Gagamitin ba nila yung Senate Impeachment Court to get evidence so that they can prove their case there? Hindi tama yun. Diba? So that in effect is some form of violation of the right against self-incrimination because gagamitin nila yung compulsion power dito when in fact the case is already pending before the Supreme Court. Yan ang malinaw na forum shopping. Ipinagbabawal ng Korte Suprema, ng Rules of Court, in fact, contemptible yung ganyang klaseng hakbang. Yun ang sinasabi natin at gusto sana nating malaman ng Senate Impeachment Court.
Pero sabi nga, hindi kumbaga, kung yung ruling dati sa Supreme Court justices ang susundin, hindi sila magpapatawag ng co-equal. Voluntary, tetestigo ba kayo? Kahit adverse.
Patungkol sa ano, yun eh. Yun nga matagal na namin sinasabi, even before they said it here. Sabi namin, hindi kami papayag kung ang purpose is purely to delay the proceedings and because kung ang patungkol nito is once again the validity of the complaint, tapos na yun eh. That has been already adjudged clearly January 18 by the Senate Impeachment Court. So kung para yun doon at ipatatawag ang ating Deputy Speaker, may ibang dahilan doon. At ang dahilan doon is to clearly divert the attention of the public. Imbis na si Chief Justice ang on trial, let's put Congress on trial. That is the tactic of the defense. The Senate will not bite into that and we will object to that.
Pero ang sinabi kanina ni Cuevas, although hindi niya in-elaborate for what purpose, for other purpose daw, and they will not touch anymore do sa validity ng complaint. Ano nakikita niyo pwede niyong testiguhan aside from that?
Well, para sa amin, if it's not with regard to the complaint and then it's irrelevant, our testimonies will be irrelevant. So, kailangan dumiretso na tayo sa Article 2, Article 3, Article 7. Sinabi nga ni Kong Miro, na pag-desisyon na yung usapin ng verification, na pag-desisyon na ito'y hinain sa tamang paraan, so wala nang kailangan pag-usapan eh.
Dagdag dun sa compliance nila, ang purpose nila sa patawag kila Kong Kimbok, Kong Erin, is to testify on the 45 properties. Yun ang purpose nila. Anong kinalaman nila dun sa pag-acquire ng mga properties? Hindi naman nila alam, wala naman silang personal knowledge kung kailan in-acquire yun, kung magkano in-acquire yun, wala naman sila alam dun sa SALN. So, kumbaga parang, in a sense, fishing for evidence. At pangalawa, gustong dungisan ang House of Representatives. Yung sinasabi ni Kong Miro na let's create a sideshow. Gawa tayo ng palabas dyan na itong Kongreso ay kumbaga maraming kalokohan. Yun yung gustong ipalabas po nila na siguro naman hindi tama na kumagat kami dyan.
Tsaka kung...
Paano kung isabina kayo? Eventually.
Pag-uusapan natin yun, no? Una, naniniwala kami, the Senate will be consistent and will give due respect to its previous decisions because if they do, that is absolutely unfair to us. They denied us access to specific individuals that would have allowed us to prove our case. In fact, the reason why we dropped the 5 other grounds was principally because napakahirap ng magpatunay doon if we cannot access to records, we cannot have access to witnesses, even ordinary court employees. Kanina po, ang tinitestify ni Congressman Toby are matters of legislative executive privilege, meaning confidential yung mga bagay na pinag-usapan na doon. It's absolutely, the media was not allowed to go in. It was clearly all members caucus. Walang pinapayagan makapasok doon. Pero pinayagan at pinahintulutan kanina para makapagsalita doon. But like I said, we have a process in the House of Rep. Kung ang Supreme Court po, sa kanila absolutely pinagbabawal nila. Absolute ang prohibition nila unless you get the approval of the NBank. So sa House, may proseso din po. It has to be presented. The subpoena, if issued, has to be presented to the Secretary General, escalated to the Office of the Speaker, and in turn presented to the House for its consideration.
Sa plenary.
Plenary or the Committee on Rules.
Of course, may implications yan, Weng, If they issue a subpoena, what would stop now the House from issuing subpoenas on the senators? So,
tsaka lalo na if the purpose is not about his SALN, it's not about his properties, it's not about his bank accounts. Ano pang dahilan? Dahilan lang dyan, tingin namin, is really just to create a sideshow, to put somebody else on trial. Sabi nga nila, sa trial, if you have no evidence on defense, you drag the trial and put somebody else on the stand. That's what they're doing.
Can we transfer na lang sa labas?